Yes.
So what does that process look like?
Well, what they'll do is they'll approach an attorney and they'll say, hey, this will, well, a lot of times they were in a previous will. That's most of the time that's the case. So it'll be a situation where a child was in a previous will, and then in the most current will, they're not in that will. So they're like, oh my goodness, I was supposed to get something and now I'm not getting anything. So they'll basically say, hey, they'll contact an attorney. An attorney will file a petition to contest the will with the orphans court. Actually, all will contests are decided in orphans court in the county where the will is being probated. So they would file a petition in orphans court contesting the will, and then they would have to, they have the presumption to prove that there was either undue influence or diminished mental capacity of the decedent. And to do that, with undue influence, they have to show that the proponent who actually is getting the money is basically had a confidential relationship with the decedent, is getting a substantial benefit, and meaning being named in the will, and the testator suffered a weakened intellect, which is typically in 90% of the will contest, that's always alleged, and that's proven with medical records. So we would get medical records from the time, and in addition to medical records, even better than that would be witness testimony of people that knew the decedent very well, that was around them at the time they did the will, and they could testify as to the decedent's, mental abilities and physical abilities and any diminished capacity that they observed.
It sounds like a serious legal process to get a will challenged.
It is. It's a very serious. The litigation can take several years, and it's very expensive because you have to depose a lot of folks and get a lot of witness statements, and it's a very long process. And that's why the biggest thing, there's ways to prevent will contests, and one major way would just be to make sure if you're going to disinherit someone, you want to give a reason why you disinherited them. If you don't want to put it in the will itself, you should attach a letter explaining, yes, I'm disinheriting my son because he hasn't spoken to me in 10 years, or he has a drug problem, or whatever the reason may be. And you can also, there's no contest clauses that you could put in your will to say, hey, if I disinherit my son, he's definitely going to challenge the will. I don't want that to happen. I'll leave him a little bit of money, like I might leave him $10,000, but if he contests the will, he gets nothing. So this way, you're giving him a little bit of a carrot, not to contest the will, and that's another way that you can, avoid it. I mean, ultimately, there's no sure-proof way to avoid it, because some folks, if they have it in their mind that they want to contest the will, they're going to contest the will no matter what. But as I said, those two ways are the most common ways: a no contest clause and just explaining, why you're doing something, and also making sure you go to the attorney yourself, not have any beneficiaries take you, because again, that proves undue influence. And a confidential relationship, if I'm taking you everywhere and you're living with me, then I may, you may not want to hurt my feelings by not giving me everything or giving me what I want. So, I might exercise undue influence over you. So that's a third thing that's very important as well, just making sure that when I interview clients that are older, I make sure they're alone. I make sure no beneficiaries are in the room. I make sure they have, capacity. They understand what they're doing and why they're doing it. And I also write a letter to my file just saying, yeah, I met with this person. I explained to them the ramifications of their decision, and they still wanted to go forward and disinherit, whoever they wanted to disinherit.